Hey there, everybody. Last will or living trust if you live in Louisiana. That's what we're going to go over this evening. I'm Paul Rabelais. I'm an estate planning attorney. Been an estate planning attorney for 34 years now. I've helped thousands of people get and keep their estate legal affairs in order. I've helped families where I helped the parents passed away. I've helped the children have passed away. I helped the grandchildren. So I've seen it. I'd like to say I've seen it all, but I'm sure I haven't. So a lot to share with you. Probably one of the most talked about issues when it comes to estate planning is on a basic level, what should people have and how should they leave their things to their survivors? Does doing it through a will make more sense, or does doing it through a trust make more sense? We'll be covering all of that here this evening. So break this down into kind of what's all the fuss. We'll talk about what is a will. We'll talk about what a living trust is. We'll talk about the key differences. We'll talk about the advantages of a will, the disadvantages of a will, the advantages of a living trust, the disadvantages of a living trust, when to use a will, when to use a living trust, and then we'll wrap it up with a summary. So a lot to share. Really going to be talking about this from a kind of Louisiana perspective. A lot of the things that I discuss, they are applicable wherever you live, but I'm going to get into some of those Louisiana nuances and really niche down. Hey, Julia, how you doing? Thanks for the flower. Thanks for whatever you got there going on in the chat. You're our first chatter. Feel free, if you do have some questions, comments, experiences that you can and share, they're positive, throw them in the chat. Everybody learns from it. I looked at the chat occasionally, address those issues and questions that can probably help everybody if I address them. So feel free to contribute. That's why we do it. The live stream is to use the chat feature. Okay, let's jump right in. So why all the fuss? Why all the fuss about will or living trust, last will and testament, or revocable living trust, last will, trust, revocable, irrevocable, all that mess? So why all the fuss? It's because it's sort of been debated over the last several decades. Different people have different opinions. Some of their opinions are based on their financial interests, I think, mainly lawyers. We'll get to that. But people have differences of opinion. So this issue just doesn't go away. Should you have a will? Should you have a trust? So it goes on. People come to me. Guy came to me yesterday. Paul, a few years ago, I talked to a couple of lawyers that I play racquetball with. And they said, as long as you don't have 50 million, you don't need a trust. And then, talk to other people. So there's all kinds of things going on out there. Some of them are good. Some of them are a little fuzzy. Hey, Laura from New York. Great. Yes, most of it will pertain to you. Absolutely. In fact, I'll point out in just a couple of instances where things may not apply to you because you're in New York and you're not in Louisiana. But I'm glad you're here, and I'm glad you pointed out you were from New York, because I'm sure we have people here that are listening that are not for Louisiana, and I want this to be beneficial to them. All right, let's start with the basics. Basics. What is a will? And when I say will, some people refer to it as a last will and testament. Some people call it a last will. I'm just going to call it a will. And so a will is it's a legal document that where as long as it's done, under the proper form, we'll talk about that. Then what it's used for is to say who gets your stuff when you die. Also says a bunch of other stuff. One of the other things it says is who's your executor or personal representative. Louisiana calls it executor, who will be in charge after you die of making sure that your bills get paid, the debts get handled, and everybody gets what they're supposed to get. So generally speaking, that's what a will is. It's to determine where your assets go when you die. Right here from the get-go, I got to tell you that your will, depending upon what you own, your will doesn't cover the disposition of everything you own. I bet there's lots and lots of people that are listening to this. They have an IRA. They have a 401k. They may even have a life insurance policy. Those types of assets, your will does not control where your IRA goes when you die, whether it's a traditional IRA or a Roth IRA. When you set up your IRA account, you were asked to designate beneficiaries, and you likely did. And so when you die, your IRA is payable to your designated beneficiaries that were designated on the most likely on the IRA account application paperwork. You can change your beneficiaries, but people do typically set up their beneficiaries when they set up their IRA account. So if someone's IRA beneficiary, they set up their IRA, they designate their beneficiary as Mary, but in their will, they said, I want my IRA to go to Fred when I die. Mary's going to get that IRA because the IRA is going to be payable to whoever the designated beneficiary is, even if for some reason conflicts with a provision in the will. There never should be a provision in a will that says I leave my IRA to Fred, because whoever wrote that will, whether it's the person who wrote the will or the lawyer who wrote it for them, ought to know better than to make a disposition of an IRA in a will. Now, I will tell you where it gets confusing is maybe if a beneficiary wasn't designated and the terms of the IRA agreement state that in absence of a designated or in absence of a beneficiary, some IRA contracts say that the IRA will be payable to the IRA account owner's estate. So when an IRA is payable to an estate because there was no designated beneficiary and the IRA contract required that, or for example, when the IRA owner listed their estate as the beneficiary, which is rare, triggers some not favorable income tax consequences when the IRA was a traditional IRA. But nonetheless, I need to mention it. Sometimes an IRA goes to an estate and then the will does govern who gets the IRA because the IRA passes through the estate and the will governs who gets the estate assets. Lots of complications there. All right. So the will, again, going back to the what is a will, it generally just states who gets your stuff when you die. But based on my previous 3 or 4 minute rant, there are some assets that you own that your will does not address because they go by beneficiary designations. Here in Louisiana, Laura, here's one of these Louisiana exceptions here. Since we are talking about Louisiana, let's talk about the different kinds of wills that exist. We have 2 kinds. Louisiana does have a bunch of unique laws, very different from all of the other 49 states. In Louisiana, we have 2 kinds of wills. We have what's called a notarial will and an holographic will. Most wills written in Louisiana are of the notarial type. They're typed up, very specific requirements to make a valid notarial will. Things like have to be signed at the end, signed on each page, has to have this very specific wording in the attestation clause at the end that really has to match the wording in the statute. And there are other requirements as well to make a notarized and witnessed by 2 people. But the people that are witnessing can't be heirs. And so lots of very particular rules that you have to meet to comply with our notarial will requirements. Nonetheless, if I had to guess, I'd say probably 98% of wills written in Louisiana are notarial wills. The other type of will in about, I think it's 27 states, allow handwritten wills without being notarized, without being witnessed. In Louisiana, we call it an holographic will. The requirements to make it valid are really, and it's really kind of simple to make it valid. Our Louisiana legislature, I guess many, many years ago, wanted to enable people to handwrite their own will and to make it easy to do it. Doesn't need to be notarized, doesn't need to be witnessed. Sure, there are requirements, has to be in your own handwriting, several other requirements. Problem with holographic wills is people get to rambling and we never know what to do with their stuff when they die, and we try to read their holographic will that they wrote by themselves. One good story was several years ago. A woman was dying of cancer. She hand wrote her own holographic will. Then she passed away, and then the daughter comes to me and said, "Here's Mom's will." She understood she could have a holographic will. She did it all of her own handwriting. And so we need to do the probate because Mom had a house and had a few other assets, and we need to get that transferred out of her name pursuant to her will. So I started reading the will that Mom wrote in her own handwriting, and it went on to say, I have a home. My mother lives with me now. I don't want her to be displaced if I die, so I want to make sure Mom has a place to live. I also have a husband, and I don't want him to be put on the street, so I want to make sure, he has a home to live in. And then she went on to say, I have a daughter, and she's 19, and I want to make sure she has a home to live in, so that's what I'm doing in my will. So this all, of course, because it was so unclear and ambiguous, and everybody was fighting about who mom's home should be transferred to after mom died. We all ended up in court, and it was just a big mess. And judge had to get involved, and it was just the relationships of the survivors suffered. It was financially expensive for the family to have to go through and deal with all of that. So, but nonetheless, Louisiana has what's called a notarial will, all typed up, notarized witness, several other requirements. But Louisiana also has one of several states that allows for handwritten wills that don't have to be notarized or witnessed. A lot of people will tell me, Paul, I was going on a trip, so I just wrote something down in my own handwriting, and I went down the street to the grocery store and I got it notarized. That never makes any sense. Because an holographic will doesn't have to be notarized. And I cringe when I even pick up that piece of paper with the handwritten instructions and say, oh boy, what kind of mess are we getting into when someone tried to handwrite their own will? Nonetheless, that's our two types of wills, notarial and holographic. Key designations in a will, obviously, who are the heirs. And so sometimes people say I leave my estate equally to my 3 children. Some people say I leave my house to this person. I leave my brokerage account to this person. I leave my vehicle to these 3 people. And then I leave everything else that I own to these 2 people. So it could be something like that. But one of the main reasons people have a will is to designate who gets their stuff. The other main designations that people make in a will is who is their executor. I'm going to call it executor because that's what Louisiana calls it. Other states will call it personal representative, or perhaps some other title. I'm going to call it executor. So the executor is the person who, once someone dies with a will and with assets in their name, like a home or a brokerage account or even vehicles, then it's the executor's job to typically hire lawyers and go through the court proceeding and involve the heirs and pay the will writer's debts after the will writer died. We call the person who wrote the will in Louisiana the testator. They wrote their last will and testament. They're called a testator, female testatrix. And so it's the executor's job just to make sure that the terms of the will and all applicable laws are followed. All right, so that's the will. Next, what is a trust? And this is where we sometimes have to start with kind of square one. What is a trust? In its legal terms, a trust is defined as a relationship between a trustee and beneficiaries. So, but let's not get into all those legal terms. There are lots and lots of different kinds of trusts. Many trusts are motivated for estate tax avoidance purposes. Many trusts are created so that someone can give or bequeath assets to another, maybe a child or a grandchild, but the donor of the asset doesn't want to dump an asset or dump a bunch of money into the lap of a child or a grandchild or any other person. So trusts are created to provide for ongoing management of that asset or of those assets for the benefit of certain beneficiaries. We'll get into that a little bit more here today. All right, so key components of a trust. You've got the settlor, who, the way I say it, the settlor is the person who signs to set up the trust. Sometimes that settlor is called a grantor. Sometimes they're called a trustor or trust maker. So that one position of the person who signs to set up the trust can be a number of different titles. And you have what's called a trustee. A trustee manages the trust assets. And since we're talking will or living trust, let's keep all of our trust talk related to this living trust concept of, instead of using a will to bequeath assets to your survivors, leaving all of your assets in your name, when you die, even though you have a will, your assets are frozen, and your executor hires lawyers, and your heirs typically hire lawyers, maybe the same lawyer. And there's a court process that has to take place where judges get involved, and judges review the terms of the will and ensure that the will meets the validity requirements under our Louisiana law. And then the judges typically sign court orders confirming that the executor now has the authority to do their job as the executor. Judge will sign court orders at the end ordering that estate assets be transferred over to the heirs. Those court orders might get recorded in the parish where the person who died owned real estate, so that court order reflects the transfer of ownership from the person who died to the heirs. So when their person has a will and dies with assets in their name, there is that, Louisiana calls it succession procedure. All other states call it probate procedure. That concept of taking the person's will, going through the court process, having a judge validate the will, having a judge sign orders, ordering that assets be transferred to the heirs. The whole idea behind the revocable living trust is eliminate that court and attorney involvement when you pass away. Fred Flintstone or Fred and Wilma Flintstone may say, you know what, I don't want the survivor of us. I don't want our children. I don't want our heirs to have to go through that court proceeding when we pass away. Fred and Wilma may say, I understand, and based on my experience and based on what I'm reading and based on what people are telling me, that court experience is expensive and it takes a long time and it's an all-around hassle. So Fred and Wilma say, you know what, we're going to get around all of that court and a lawyer involvement. We're going to create our Fred and Wilma Living Trust. And we're going to transfer assets that would have been in our estate because they were in our names when we died. And we're going to transfer those assets to our Fred and Wilma Living Trust. So our home on paper will be retitled from Fred and Wilma to Fred and Wilma as trustees of the Fred and Wilma Trust. Our brokerage account at Vanguard or Charles Schwab or Fidelity Investments or Edward Jones or wherever it is, our investment account will be retitled once our trust gets established from Fred and Wilma to Fred and Wilma as trustees of the Fred and Wilma Trust. And we will have created that Fred and Wilma Trust instrument, probably used a lawyer to do it. And in that trust instrument, it probably says something like, I'm dumbing things down and keeping it really simple here. Fred and Wilma can do whatever they want to with the trust assets while they're alive. When one of them dies, the survivor of them stays in control of all of the assets and can do what they wish with the assets. And then the trust says when Fred and Wilma both have passed away, then maybe their daughter Pebbles, if she's old enough and responsible enough, is designated as, instead of executor of a will, Pebbles is designated as the successor trustee of Fred and Wilma's Living Trust. And so Pebbles then takes charge of the trust and she makes distributions from the Fred and Wilma Trust to the beneficiaries who are designated in the Fred and Wilma Trust instrument. And all of that, I call it trust administration or settling of Fred and Wilma's trust. All of that is done outside of any kind of court succession, as we call it in Louisiana, probate, as it's called in other states. Things that are titled in the name of Fred and Wilma's trust when they die, things that are in a trust, they don't have to go through the probate process. The probate process is only for assets that are titled in your name when you die. They're frozen, got to get the courts involved. Assets in a trust don't have to go through that. That successor trustee. If Fred and Wilma have a home and it's titled in the name of the trust, and Fred and Wilma both die, and Pebbles says, I live in another city. I don't need my parents' home. Then Pebbles, the day after Fred and Wilma die, Pebbles can stick that for sale sign in the yard and sell the house. She's the trustee. Don't have to wait on judges and lawyers and all of that to get involved. It just streamlines the settlement of passing along Fred and Wilma's assets to their survivors. Glad you're here, Chelsea. Good to see your name again. 227, whatever that means. But nice to see you here. Okay, so that's the living trust concept, while the key participants in I'll call it a will plan, are the heirs and the executor. The key players in a trust plan are the settlors, the people who set it up, the trustees who, while the settlors are alive, the trustees are often also the same people as the settlors. But then I'm going to say a key role is the successor trustee to handle trust assets after one or both of the settlors dies. And then we call people who inherit through a trust, we call those people beneficiaries, or if we really want to get technical, they're often called principal beneficiaries of a trust, because there's two kinds of beneficiaries: income beneficiaries and principal beneficiaries. All right, so the key differences here between a will and a living trust, it's really from a tax perspective. I mean, generally speaking, of course, our tax code is very complicated, and there's all kinds of different kinds of trusts and things that people do to try to minimize or avoid tax consequences. But generally speaking, the will or living trust is not the decision of whether to have a will plan or a living trust plan is typically not driven by taxes. All of the same estate tax advantages of deferring estate tax when the first spouse dies, making sure both spouses utilize their estate tax exemption, all of that is applicable whether you have a will or a trust. So it's not a tax-driven decision. It's more of a probate versus avoid probate, or as we call it in Louisiana, succession versus avoid succession decision. Again, like I said, the traditional way this has always been done over the years. When you watch the movies, when you read the novels, you read about people writing their will and or having their will, or the reading of the will, which doesn't happen very much anymore because of electronics, and things are passed around so easily electronically. But nonetheless, the idea that the key difference here is when someone has a will and they have assets in their name when they die, then there's those assets are going to be frozen. Things like business interests, brokerage accounts, often bank accounts, homes, real estate, those things are frozen, and they're not going to be passed along to the heirs who are described in the will until those heirs and the executor hire lawyers. Lawyers prepare court paperwork, and judges get involved, and all that requires expense and delay. I will say, New York person, that I've interviewed on YouTube many lawyers from different states, and if you watch some of those videos, they're titled, on my channel. I asked them specifically to describe their state's probate experience, and there is varying degrees of probate difficulty from state to state. Probably California is one of the worst insofar as how long it takes, the delays that are required, the court appearances that are required, the expenses that are involved, the court filing fees, the lawyer fees. So California is just all the California people I've talked to. It's like you want to avoid probate like you avoid the plague if you're in California. But there are varying degrees of probate. So, for example, I've interviewed many probate lawyers from various states, and again, some of those lawyers tell me they have to attend court hearings, or now maybe they'll kind of brag a little bit and say, now we can do some of those court hearings in Zoom, and that they're required in every probate. But here in Louisiana, unless something's contested, which happens sometimes, but the typical succession, there are no court hearings. People aren't heirs, and even lawyers aren't going into a courtroom and getting in front of a judge to complete the succession. Yes, lots of court documents get prepared. Yes, lots of petitions and court documents get filed at the courthouse. Yes, those court documents have to make their way to a judge's office, and some judge's law clerk reviews them and often tells the judge where to sign if all of the paperwork is done in the law clerk's opinion accurately. So, and there is, delay in that, but there are some states that are really kind of nightmare probate states. And then there are some that are maybe not as much of a nightmare states. And I'd say Louisiana is probably one of those not as much of a nightmare state, just because there aren't these required court appearances. But Nonetheless, it is a court procedure. It is a court proceeding. And whenever you get the courts involved in a matter, there's going to be expense because there are lawyers needed to complete a succession. Again, another thing, I've talked to other probate lawyers in other states, and they're like, no, the public can just go down to the courthouse, and our state provides the consumers with probate forms that they can use. That just doesn't happen in Louisiana. Virtually every probate is done with must be done with the assistance of lawyers, because the detail required and the customization required in all of the court pleadings is just not something that a typical layperson can handle. All the legal mumbo jumbo that has to be in there to satisfy the requirements of all the succession pleadings. Okay, but that's the key difference. Have a will. Your survivors are going to go through the succession process, have a living trust, and have it what we call funded correctly. The assets that would otherwise have to go through probate when you die, they get retitled during your lifetime to your trust, because things that are titled in the name of your trust don't have to go through that probate. That's the key difference between a will and a trust. There are some other differences. I want to talk a little bit about the privacy issue. A lot of just the generic articles written nationally, they say you should have a living trust because that living trust will ensure more privacy to yourself and to your family. Well, Louisiana's got a couple of angles on that. So a probate in Louisiana does not necessarily have to be as public as a probate in other states, and a living trust in Louisiana probably is a little more public than it is in other states. Let me explain. So one of the advantages of one of the general premise is, if you do a will, there's going to be a probate when you die. The will's going to be public record, which it will be. Inventories of assets have to be filed at the courthouse, showing all of your bank accounts, your brokerage accounts, the value of your home, how much money you had in each account at the bank, what your stocks were worth, what your LLC was worth. And then, and all that is in the public record because it's part of the public succession proceeding. Well, now when we do these successions, really any, let's see, I've got the statute up right here. The sworn, what does the statute call it? Statute calls it the detailed descriptive list. The succession document that has to get filed at the courthouse that makes some people cringe when they hear it's going to be filed at the courthouse and going into the succession record. The one that makes people cringe, it's the court document called the detailed descriptive list. Because, if a husband dies, the detailed descriptive list that maybe the wife gets the information to the lawyer and the lawyer prepares it. But that detailed descriptive list is going to show every bank account that they have, the account balance, every debt that they have, every credit card account, the value of all the vehicles, the stocks. And so it's most people spend their whole lifetime trying to really keep their financial information close to the vest. But then they die and all this information gets filed into the succession record. Well, we do have a statute that says that the detailed descriptive list, it can be sealed upon the request of certain people, this executor or what's called independent administrator if there was no will, or heir, or what's called legatee. So in most successions these days, that detailed descriptive list is not public to the world, but the terms of the will and the judgment of possession, which shows who's inheriting the assets, doesn't necessarily show the value of the asset, but it shows who's inheriting the asset. That's public record. So just want to make that distinction in Louisiana about our statute that we have that allows this detailed descriptive list of all the assets to be sealed. Now, when we talk about, a lot of people talk about, well, you should have a trust if you want to keep all of your affairs private, because again, trusts, and by their nature, they're a very private thing. When you pass away, the trustee takes over and distributes assets to the trust beneficiaries, all outside of the very public court proceeding. So, but Louisiana has a special rule. Let me find it on my screen here. Yeah, it says that when a trust owns real estate. Now, if the trust owns no real estate, it owns accounts, and then everything does stay really very private. But when a trust owns real estate, um, then what's called an extract of the trust. Other states call it certificate of trust, but we call it extract. An extract of the trust must be recorded in the public records, the parish conveyance records, as we call it, where the real estate is located. So, and I think a question about a house. We'll talk about that in a second. But if in Louisiana, Fred Flintstone's house is transferred to the Fred Flintstone Trust, then now additional information needs to be in the public records of the parish, things an extract which has the name of the trust, a statement as to whether the trust is revocable or irrevocable, the name of each settlor, people who set up the trust, the name of the trustee and the beneficiaries, the date the trust was executed, and any limitation on the power of the trustee to handle real estate. So there is when a trust owns real estate in Louisiana, there is a little bit of information, the things that I just mentioned, that does go into the public record. But if the trust doesn't own real estate, then nothing needs to be recorded in any kind of public record. So I guess if someone was really interested in privacy in Louisiana, we might have a trust just for the real estate, and then information on that trust goes into the public record, and then a trust for all of the non-real estate assets, and all that remains very private. So there's a few asterisks next to the don't get a will because everything's public, and do get a trust because everything's private. In Louisiana, there's a couple of nuances there. All right, let me bust over here to Laura. How difficult, because it's an appropriate question. How difficult is it to move your assets like a house to a living trust? I'm guessing it's best to get a lawyer to get things set up. So two questions, or a question and a statement. So I talked about maybe Fred and Wilma Flintstone. They have a home, and they want the survivor of them, and they want their children or other heirs to avoid that probate when they die. They're going to set up their living trust, and then they're going to sign a document that reads, and again, I'm being real simplified here, but that document is a document that Fred and Wilma signed, typically prepared by the same people who set up the trust. And it says, I, Fred and Wilma, transfer my home at 123 Bedrock Street to Fred and Wilma as trustees of the Fred and Wilma Trust. So all that gets signed by Fred and Wilma, gets recorded in the conveyance records of the parish where the property is located. If it's Louisiana, if it's another state, it'll get recorded in the county. That's how real estate gets transferred to a trust. And yeah, it is best to get a lawyer to get things done. Problem with, there's so many variables to estate planning. And the problem is you at least often don't know there's a problem until after somebody dies and you can't fix it. So that's why you want to typically work with a lawyer who does this stuff, day in, day out, and it's less likely that mistakes will get made or things will be missed. All right, good question here. Chelsea says, do both probate and non-probate assets need to be part of the detailed descriptive list filed with the court? I'm going to say generally no. I mean, if an IRA, for example, it doesn't go on the detailed descriptive list unless the IRA was payable to the estate. A life insurance policy doesn't get listed on the detailed descriptive list unless the life insurance policy was payable to the estate. So general answer is no, just the probate assets get listed on the detailed descriptive list. Good question, Chelsea. All right. Let's now move to the advantages of a will. When is it, kind of appropriate from, I'd say, we see a lot of people go with a will plan. And when you hear me talk about will plan and trust plan, when someone does their will, they typically don't do just a will. When someone gets their legal affairs in order and they choose to do it, they choose to use a will as the instrument where they leave things to their desired heirs when they die and they name an executor. They're also, in addition to their will, they're going to create powers of attorney, probably one for financial matters, one for healthcare matters. had people take care of that stuff today, where married people also often designate their spouse as their agent on their power of attorney, and maybe name an adult child, if they have an adult child, who's responsible as the alternate agent on their financial and healthcare powers of attorney. So when I say will plan, will powers of attorney in Louisiana, we call it a living will, which is a statement about life support machines. Don't get living will mixed up with will or last will and testament. A living will has nothing to do with who gets your stuff when you die. A living will is your statement regarding whether you'd want, regarding medical treatment if you're in that profound vegetative state with no chance of recovery, and the doctors have determined that your death is imminent and there's no chance of recovery. Your living will is where you state your wishes to your family and doctors regarding typically the withholding and withdrawal of life support systems. So that's all part of the will plan, the will, the powers of attorney, the living will, or the trust plan, which is the living trust, the powers of attorney, the healthcare documents, the living will. And when someone has a living trust, not to confuse you, but I've got to lay it all out here, they also have they also have a will, and it's called a pour-over will. That's the slang term for it. When someone when Fred and Wilma Flintstone set up their living trust, all of the who gets their stuff when they die, it's all written into the terms of their trust instrument. Now, if Fred and Wilma die and they have an asset in their name because it didn't get titled into the trust while they were alive for a variety of reasons that might have happened, then like if Fred dies, Fred's will needs to be used because he had those 25 shares of company stock that he had in his name. And so they weren't in his trust. So we have to use Fred's pour over will, go through probate. Those 25 shares of stock may be the only probate asset, but nonetheless, the probate is necessary to get that asset transferred. The pour over will generally says, if I have anything in my name when I pass away, I want it poured over into my trust. So the probate is necessary to do that. So the idea behind a living trust is make sure it's funded, make sure everything you own that needs to be in your trust is in your trust. Again, not your IRAs, not your Roth IRAs, not your life insurance. You have beneficiaries on that. All right. People use a will plan maybe because they want things to be as simple as they can be for themselves. Some people might say, I want a will because I want it to be simple for me. I don't want to retitle anything I have. They might in the back of their mind be saying, I realize when I die, because I'm doing all this through my will, my heirs will have to go through a court proceeding or a succession. But maybe in the back of their mind, they're saying, I'll be dead. It's not my problem. And not necessarily in a mean way. Or sometimes it's a cost effectiveness thing. Now, look, I realize if somebody has a $3 million estate, and they're facing, significant probate expenses when they die, maybe a couple or $3,000 extra to put that trust plan in place to save, who knows, maybe $20 or $30 or $50,000 of expenses when they die and a year of delay. And look, you plug in whatever probate expense you want to plug in, and you plug in whatever probate delay you want to put in when we have this conversation of what is avoided when you create a living trust and transfer your assets to a living trust. But nonetheless, for someone who has maybe a $70,000 to their name kind of thing, it may be better for them because they're trying to hang on every dollar that they have because they worry they're going to run out of money. They have $70,000 to their name. And so, they're 80 years old. And so I almost hate to see those people spend the extra money, the extra couple, $3,000 or whatever it is to create that living trust, because they need that money to live off of. So maybe the will plan is right for them. So people who want to keep things simple for them, even though it may trigger extra stuff when they die, that's okay. They make that decision. Some people look at it as the kind of pay me now or pay me later kind of thing, the old Midas Muffler commercial, if it was Midas Muffler, where you can either kind of keep things simple now, and then have the estate pay those probate expenses when you die. Keep things simple now by just leaving everything in your name and providing in your will where it goes. That's the kind of pay me later attitude versus the kind of pay me now, which is get everything structured so that your survivors don't have to go through anything and often don't have to incur any expense when you pass away. Good evening, Gina. All right. And so simplicity is often kind of the will plan reason, the cost effectiveness, the short-term cost effectiveness, not necessarily the long-term cost effectiveness. Also in Louisiana, people typically, if you have minor children, that's often done through a will. So that's in Louisiana, it's called who's the tutor of your children, who's going to have those parental rights if the parents pass away before the children reach the age of majority. That's often done through a will. Some of the perceived disadvantages of a will, that succession can be lengthy and expensive. Is every succession a nightmare where the family fights and relationships fall apart? Of course not. I've handled many successions where we did what we needed to do. Family was good before, family was good after. And, if they had to wait a little while to get the assets, no big deal. They had to incur some expense to get the succession done. No big deal. Pile of money there to take care of that. So many successions, they work. But they can be, and typically the more people that are involved, the more assets that are involved, that's when the probate becomes more difficult, because if somebody has 14 different accounts at 11 different financial institutions, now we're getting the lawyers of 11 different financial institutions to review court orders and court documents, and that just, it goes on forever. So that's kind of the disadvantage of the will plan, is that succession can be lengthy and expensive. And again, there's that public record aspect of it. However, that detailed descriptive list can be sealed. And then some of the advantages of that living trust, the main one, the one you read about, see about all the time, avoid probate. Assets that are in your living trust when you die, that successor trustee can jump in right after you pass away and make the distributions to the appropriate beneficiaries, all outside of lawyer, court, judge involvement. So that's the big key there of that living trust, is avoiding the probate. We mentioned here in Louisiana, not quite as much of a privacy factor, because if a trust owns real estate, then certain information about the trust must be recorded in an extract that does get recorded in the public records of the parish where the real estate is located. So anyway, got to be aware of that. And just, you're going to have a potential for just a faster distribution of assets. Like I said, let's say Fred Flintstone had a trust. He owned some land. He left his land to his 4 children. But he left it from his trust. During Fred's lifetime, Fred created the Fred Flintstone Living Trust, and he transferred that land, that 200 acres of land or whatever it was, to his trust, and wanted that land to go to his 4 children when he passed away. So because it was in the trust, Fred designated his daughter Pebbles as the successor trustee. The day after Fred dies, Pebbles signs a document transferring that land from Fred's trust to the 4 children. The 4 children sign accepting their portion of the land. And that all gets done the day after Fred died, as opposed to what's months or sometimes years of having to put that land through a probate process. All right. If there's a disadvantage to the living trust, I'd say, there is typically, I'm going to call it a little more expense in getting the trust plan set up over the will plan. However, that additional expense is often tenfold made up by eliminating the probate expense or succession expense when the trust settlor died. And it also does require, people will ask me all the time, well, what are the disadvantages of a living trust? The first thing that comes to my mind is, If that trust is not fully funded, if the assets of Fred Flintstone during Fred's lifetime are not transferred to his trust, then it's likely that he defeated the purpose of creating the trust, because a probate or a succession is going to be required to transfer the assets that were in Fred's name when he died that didn't get transferred to Fred's trust. So, not that it's a disadvantage, it's just we want to make sure if you're using a living trust and your primary objective of it is to eliminate the need for a succession, then just as important as creating your trust, just as important is what's called funding your trust, or titling those assets that are in your name and would go through probate when you die, or a succession if they're in your name, getting those assets transferred to your trust during your lifetime. So those assets are already in your trust when you die, and then your successor trustee can manage those and distribute them to your trust beneficiaries, immediately. All right. I'm going to say here, and let's see, could you do Medicaid asset protection trust instead of living trust? You seem to have gotten a hold of some lingo, Chelsea, of Medicaid asset protection trust. It's kind of the lingo some lawyers use. You must have read that somewhere. So technically speaking, Chelsea, a Medicaid, as you call it, a Medicaid asset protection trust is a living trust. Because when you write the words living trust, that means a trust that you set up while you're alive. And I'm being nitpicky here, but maybe I think what you're really asking, if I kind of dumb it down a little bit, can you do a very particular type of irrevocable trust that is designed to keep those assets in the trust from having to be spent on the nursing home expenses of the person who created the trust? Can you do that instead of a revocable living trust, which doesn't get the assets out of anyone's name for long-term nursing home, Medicaid, that protection? So yes, we realize that. I've very familiar with our long-term care Medicaid eligibility rules. I have set up many trusts for people who their number one goal, because they were, I'm going to give you a case study here. They were 70 years old and they saw their parent run through several $100,000 in a nursing home. So the number one goal of the 70-year-old, how can I protect my money? How can I protect my land? How can I protect the value of my house from having to be consumed if I go into a nursing home that costs $8,000 a month? How can I avoid having to deplete my assets? So that's another discussion that will be the topic of an upcoming YouTube live stream. So stay tuned on that. But yes, very, very familiar with that. All right. So good, Chelsea. You attended a webinar for CLE credit. Okay. So if you got CLE credit, you must be a lawyer, Chelsea. So good for you. And it was technical, so wasn't sure. Thanks for clarifying, Paul. So CLE credit, continuing legal education. And I've taught many of those CLE classes in the past on all of this stuff. Okay, so I'd say though, let me tell you, put it in, give you my experience, decades of doing this stuff. Here, and look, I'm here in Louisiana. I help people in Louisiana. You might think I'm an estate lawyer and all I do is I represent billionaires who try to pass along their billions and their hundreds of millions, but I'm in Louisiana. So I work, a lot of my clients have been the people who, they just retired from the plant and they've got their house and they've got their IRA and they've got their checking account and they got their pickup truck. And so, they rolled over their 401k or whatever it was called based on the company that they worked for. They rolled that over into an IRA and they're just trying to preserve as much as they can for their survivors, for their loved ones. So when I present the masses of those people with that option of, would you rather have a will plan where you simply keep everything in your name, create your will, create your powers of attorney, Yes, when you die, your survivors will hire lawyers and go through a court process. I'm not saying it's going to be a disaster, and I'm not, not saying it's going to be World War III, but there will be a court proceeding when you pass away, and there's going to be some, government and there's some lawyer and court involvement, but that's okay. Or would you rather create your living trust? And under that scenario, when the first spouse dies, the surviving spouse typically they just stay in control of everything. And then when the surviving spouse dies, you've designated a trustee to distribute the trust assets to your beneficiaries, your children, whatever the case may be. And all of that gets done outside of any lawyer and court involvement. I would say when I try to objectively, give people those options, I'd say probably about 90% to choose that trust option. I think estate planning is one of those things where people are saying, this is, I'm getting older in life and I'm not going to, I'm not going to live forever. I'm not getting any younger. And so when it's my time, I want to make things as easy as I can for my survivors. So I think that's kind of the main reason people opt for the trust plan is yes, having that will plan does require a court proceeding. Is Louisiana's succession a little more streamlined than some of the other states' probate proceedings? I'd say yes, but it's still a court proceeding. And you still have all of the inherent problems of court proceedings, from dealing with clerks of court, dealing with judges, dealing with lawyers. And a lot of people like the thought of eliminating their survivors from having to deal with that hassle. So most choose that living trust, but it can be done either way. All right. So Laura, great. Wanting to learn more about that too. Good. I think we got all the chat covered. All right. So that was a good one, and lots more planned. I made a list here of all the topics. So I wanted to address. So y'all stay tuned. Check my channel out from time to time. We'll see you next time. Thanks, guys.